Key parties. The initial case in 1997 involved the Supreme Court of Missouri versus Christopher Simmons. The subsequent case that dealt with international law was Roper versus Simmons.
Relevant context and legal mechanisms. In 1997, the Supreme Court of Missouri found Christopher Simmons guilty of first-degree murder. However, at the time of the murder, Simmons was only 17 years old. This is relevant because in the state of Missouri, the age required for capital punishment of any crime was set to the minimum age of 18. Nonetheless, the court decided to sentence Simmons to death, at which point Simmons appealed the decision and it was brought to the U.S. Supreme Court. In Roper v. Simmons, by a vote of 5 to 4, the U.S. Supreme Court held that the 8th and 14th Amendments forbid the execution of offenders who were under the age of 18 when their crimes were committed. For the purposes of this case, the 8th Amendment prohibits the imposition of cruel and unusual punishment, while the 14th Amendment asserts that the state cannot deny any person in its jurisdiction equal protection of the law. The U.S. Supreme Court also considered the UN Convention on the Rights of the Child. At the time of Roper v. Simmons, all countries of the world had ratified this convention, with the notable exception of Somalia and the United States of America.
Arguments put forward on each side. Those in favor of overturning the Simmons conviction, upheld by the Supreme Court of Missouri, argued that the evolving standard of decency of a maturing society forbid the execution of Simmons, as it constituted a disproportionate punishment, as well as cruel and unusual punishment. The court reasoned that the rejection of the juvenile death penalty in the majority of states, the infrequent use of the punishment even where it remains on the books, widespread international public disavowal of the practice, and the consistent trend towards abolition of the juvenile death penalty demonstrated a national consensus against the practice. The court determined that today our society views juveniles as categorically less culpable than the average criminal. Those in favor also argued that the 8th and 14th Amendments forbid the imposition of capital punishment on those under the age of 18 at the time the crime was committed. Justice Kennedy argued, when a juvenile offender commits a heinous crime, the state can exact forfeiture of some of the most basic liberties, but the state cannot extinguish his life and his potential to attain a mature understanding of his own humanity. Dissenters of the court's decision, notably Justice Scalia and Justice O'Connor, argued two separate points. First, that international disapproval of capital punishment of juveniles has no place in the legal opinion of the U.S. court. Second, the line between adult and juvenile was questioned. The argument put forward claimed the difference in maturity between adults and juveniles was neither universal nor significant enough to justify a rule excluding juveniles from the death penalty.
Cases for each side. Those in favor cited Atkins v. Virginia, 2002. This case determined that the imposition of capital punishment as a sentence for a mentally handicapped individual was cruel and unusual punishment, and therefore contrary to the 8th Amendment. This gives reason to suppose juveniles should not be penalized via death penalty because, in a similar fashion to a mentally handicapped person who cannot truly grasp the severity and implications of their actions, a person under the age of 18 years of age has not mentally matured to a sufficient state. Those who dissented cited Stanford v. Kentucky, 1989. This case decided that the execution of those aged 16 or 17 was not constitutionally barred and did not violate society's standard of decency.
Resolution reached and implications. The resolution this case determined was that those individuals under the age of 18 cannot be subject to the death penalty. Roper v. Simmons demonstrated that the international norms of other states influences the U.S. court's understanding of the evolving standard of decency, as well as what qualifies as cruel and unusual punishment. The opinion of the world community is relevant, though not controlling, to the consideration of the juvenile death penalty in the United States.